Mother has blocked all access to the minor child, Blake, by my client, made it so that he can't contact them and vice versa.
She took adult toys out of our bedroom, and that didn't happen just once. It's happened on multiple occasions. Gerald's girlfriend is going to be her new mother. They are buying a house, and they're doing that after the divorce so that I can't get the house.
Court will note the appearance of Ms. Ballast on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for return of children. Ms. Ballast, go ahead.
Good morning. Thank you, Your Honor. We filed notice of this motion on July 9th, 2024. I had an earlier motion before this court, which was seeking the same relief at the time of the filing of the complaint. I'm sure the court has read my motion. Mother has blocked all access to the minor child, Blake, by my client, made it so that he can't contact them and vice versa. We're asking for the same relief we were seeking earlier, and significant time has passed because the mother refused personal service by a process server for nearly a month since the filing of this case. So some of my facts are a little bit old, but the relief is still the same. Blake should be with his father. He should be granted temporary sole legal custody and physical custody, and the court should set an expedited hearing for this matter on those issues.
Okay, thank you. Ms. Shoemate, what's your response?
Your Honor, both of my children have lived with me from birth since until Gerald and Zoe moved to Quincy in April. And Gerald could have contacted me at any time to ask about Blake. He has not done so. He has messaged.
All right, guys. Today we are diving into a courtroom battle that turns intense within seconds. The father's attorney claims the mother completely blocked access to the child, while the mother fires back with disturbing accusations that instantly change the tone of the hearing. From hidden secrets to custody demands, this case wastes no time, pulling everyone into pure chaos.
Me regarding other things, but not any concern for Blake. I've expressed my concerns to CPS concerning my daughter. She took adult toys out of our bedroom, and that didn't happen just once. It's happened on multiple occasions. When I talked to my daughter, there was no support from Gerald or any concerns regarding the fact that she had adult toys in her room. From then on, she started anywhere that Gerald went besides work. She was with him. He would go into her room without knocking as she was changing her clothes. There was rumors going around at school. And I talked with Gerald about those rumors, and he was not concerned with them at all. He just kind of blew those concerns off. I had a friend named Shayna over that was visiting. She witnessed Zoe rubbing her feet on her father's legs, in between his legs, up her chest and in her stomach, and on his stomach. And the only time that he said anything to her was when she put her feet in his face. And she kept moving closer down so that she could rub on him more. Shayna got my attention to this, and I witnessed it. When I stood up, I asked him why he was letting her do this and that he should not be letting her do that.
Ms. Shoemate, you had made a referral to CPS, but they did not investigate. Is that correct?
Correct. Well,
Okay.
they said they investigated, but there was not a true investigation on any.
They did not substantiate anything, is it?
Because this is where the courtroom gets seriously uncomfortable. The mother begins describing alleged behavior involving the daughter that leaves the courtroom stunned. Rumors at school, strange interactions at home, and claims of ignored concerns suddenly transform this custody fight into something far darker and way more explosive.
Correct.
Okay.
Correct.
Anything else that you'd like to tell me?
I have tried to make contact with my daughter, Zoe. Anytime that I contact her, she tells me that she doesn't want anything to do with me. She has called called me names, that she's, you know, only listening to her father, that Gerald's girlfriend is going to be her new mother. And I have all those text messages, that when they move from where they are currently staying at in a camper, they are buying a house, and they're doing that after the divorce so that I can't get the house. There has been an occasion where Colton, Gerald's oldest son, was at our house, and Jerry was rubbing and pushing himself up on Zoe. And that he slapped Zoe across the face. I did tell CPS that. And I have text messages from Colton stating that.
Thank you.
I have.
Well, what the court's gonna do on a temporary basis, it does sound, court does note that the children were enrolled in Quincy apparently, although Blake was enrolled in Lakeview since the beginning of his schooling. So there's some issues obviously there. Parties did separate in March of 2024. What I'm gonna do, it does appear based upon the pleadings and what's been filed in this matter, that the status quo was with the children in the plaintiff's care. The court is going to maintain the status quo. The court will grant the motion, place the children in the plaintiff's custody at this time on a temporary basis. Court will order support, and the defendant will have to pay support consistent with the child support formula and guidelines, and defendant will have standard parenting time. Mr. Shoemate, what that means is that the defendant has parenting time with the child that's in your care. Well, with both of the children, she'll have on an alternating weekend basis, one midweek.
Now the pressure keeps building as CPS investigations, emotional text messages, and accusations involving multiple family members start piling up fast. The mother claims her daughter has completely turned against her, while also accusing the father of manipulating the situation behind the scenes. Every statement here raises the stakes even higher.
Per week, as well as alternating holidays and etc. So you'll have to make sure that that's accomplished, sir. And
Your Honor,
go ahead.
I have had Blake since the separation. This is not a case of him going back into Gerald's care. I have had him.
No, absolutely not.
Okay, hold on. I don't need to take any testimony from parties. That's going to be the order of the court. Court does, we'll have to address that later when we can have an evidentiary hearing, but it appears that based upon the enrollment, et cetera, of the kids in the school, that it would show that the child was in that particular locale. So the court will continue that. Court does note that the defendant moved to Vicksburg, apparently, which is outside of any of the school districts where the children had resided. So that will be the order of the court. And Ms. Ballas, you can submit under a 7-day notice of entry.
I'd be happy to do that. Can I ask a further clarification?
No, we're done. You can ask clarification, but go ahead.
How soon should the children be returned to plaintiff?
Well, they should be returned immediately. So I say tonight at 6:00 p.m.
Thank you.
The last month and a half, I have not seen my child. It's been the worst absolute month and a half of my life.
I have had this child since she's been in this world. And you know that. You know that.
Anger and emotionalism settles nothing.
Because the judge finally steps in and delivers a decision that completely shifts the case. Temporary custody is granted, emotions explode in the courtroom, and the mother breaks down while pleading her side one last time. What started as accusations now ends with a life-changing ruling made right in front of everyone. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.